Today's presentation is entitled Public Benefits 101, Issue Spotting and Appeals. Our presenter is Annie Gonring. Annie graduated from Marquette Law School and has been volunteering with the MBLC, both as a law student and now as an attorney. We're really grateful for her every time she's at the UCC. Annie works at Legal Action of Wisconsin in the Senior Law Project. Senior Law assists individuals 60 plus in Milwaukee and the surrounding counties with public benefits, housing, and consumer issues. And Annie is also on the State Bar of Wisconsin Legal Assistance Committee. Today, she's going to be talking about public benefits really in the clinic setting. And while it is a very wide area of law to pack into like 50 to 60 minutes, I know she's going to cover a lot of content, so feel free to drop your questions into the chat and I can read them aloud for her during the session. And thanks for being here today, Annie, and I'll turn it over to you.
Thank you, everyone, for joining this very basic overview of public benefits, issue spotting, and appeals. I will just point out and thank that my supervising attorney, Matt Hayes, is here as well. He supervises the Milwaukee Public Benefits Unit and then the Senior Law Project. He's just here to help field some of the questions with me because, as Katie pointed out, this is a very big area of the law and a lot to fit in. So let's get started. Organizing our presentation today by agency, essentially. If you take one thing away from this presentation, it's that knowing who you're working with, essentially, is very important and a good first step in pushing people in the right direction with benefits. We can't go over every single public benefit today, certainly, just I'm going to go over the more common ones on the screen here. So why this CLE? Just to define public benefits, we're referring to government-funded programs designed to provide financial support or services to individuals or families, generally based on need. And why the CLE? It's very likely that most of our clinics have, or most of our clients at clinics have experience one way or the other in public benefits. If they don't have experience with public benefits, it's possible or likely that they are eligible for public benefits. And, to provide a more holistic clinic experience for our clients, it'd be helpful to know when to point them towards these resources. Just as I note, the state of Wisconsin Department of Health Services, published on their website that over 250,000 people are enrolled in Milwaukee County in Badger Care Plus alone. That's just one, benefit and one benefit program. So it's very likely we're seeing clients who have experience with public benefits. Just some very brief important notes. As I've said already, benefits are complex, and especially in this political climate, they are very, they're ever changing. They were before this political climate. Just going to plug the National Center for Law and Elder Rights. NCLR has a lot of trainings on the topics we'll go over today in more detail. It's a lot to fit into 50 minutes. So if you want more information on any topic, NCLR is a good place to start. And the rule of thumb is always, because of that ever-changing nature, to double check the sources and the resources before giving a client affirmative advice on benefits. And focus, just to field questions, is on what we can do for our clients in the brief clinic time that we have. There are a lot of complicated questions that are going to arise today, certainly. My email is at the end of this PowerPoint. I would just ask you write down those more complicated questions and send me an email after the presentation. So to jump right in, to start with the Social Security Administration benefits, we're going to go over SSDI, supplemental security income, as well as SSI. There's a lot of misconception and confusion between these two benefits because they can be based both on disability. You'll have clients that'll just very simply say, like, I'm on disability, or I get disability, and it's kind of difficult sometimes to tell, what benefit they could be referring to. But there are a lot of differences between the two, and we'll go over those, briefly in a second. Where to look for answers regarding Social Security issues in general, but certainly SSDI and SSI. There's the law, the federal laws that govern them right there, but I would definitely start with the POMS, the Program Operation Manual. It is very complex, expansive. There's a lot of information in the POMS, and sometimes it can be difficult to navigate, but it is organized by benefit, and you'll get the answer to pretty much any question in there. It summarizes not only the law, but policy updates that aren't necessarily going to be reflected in the regs and the statutes. And then you can always point a client or yes, you can always point a client in the direction of their local field office. If you do help them find their local field office by zip, it's just going to give you the national 1-800 number. So for future reference, I included each of the field offices' direct phone numbers in this slide as well. So as an aside, this PowerPoint is going to be structured through the life cycle of each benefit, I guess. We're going to focus on eligibility and application, and then post-eligibility issues, and then appeals. So for SSDI, eligibility and application, the eligibility, albeit can get a little complicated. But first and foremost, you need to have a disability or one that ended within 12 months before the month of your SSDI application. And disability, bear with me, is a lengthy definition. It is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So it's a very lengthy definition, but this is the same definition for most disability determinations, including SSI. The physical or mental impairment needs to be of such severity that the claimant is not only unable to do their previous work, but can't do some type of equivalent work based on their age, education, and work experience in the national economy. And there is a list that Social Security uses to find those jobs that someone could do in the national economy. There are some very ridiculous, to be honest, jobs on that list. They filtered it a lot, but like scuba diver used to be on the list. It's no longer on the list of jobs, but it is why you see a lot of issues, this disability determination in general, at the application stage. People are determined not disabled because of just the breadth of the disability determination requirements. You also need to be insured for disability. This is one of the biggest differences between SSI and SSDI. Being insured for disability is based on your earnings and your work record. And this is where it can get very complicated going into, if you have enough quarters of coverage to be insured for disability. It's pretty much, just to break it down very simply, is have you earned enough and worked enough into the Social Security system to be insured for disability under the SSDI program. And then you generally need to be below the full retirement age. Once you are eligible for full retirement, you're just going to get full retirement benefits. And because it takes a good amount of time to apply for SSDI, it's usually very difficult, if not impossible, to get it after 65. Which brings us to the first complaint in this section of SSDI benefits, which is timing issues and complaints. Setting clients' expectations that this is not an immediate process is very beneficial and important. Letting them know that this is actually a very long process. If you call the local field offices now, you get about 2 minutes of a pre-recorded message before you're put on hold. And in that pre-recorded message, they say, we are very behind on SSDI applications. They are very behind. So it's important to set those expectations just because of low staffing issues, and just the length of time is built into the eligibility requirements as well. There's a 5-month waiting period, etc. And then, like I said, you'll also get denials based on lack of finding that someone is disabled. There is a 5-step process in determining disability. There's 5 questions, I guess, that the workers go through, or the DDB goes through, the Disability Determination Bureau, which is actually a DHS state of Wisconsin entity that SSA contracts with to do these disability determinations. They you can be denied at any stage of that 5-step process, essentially. And like I said, it's the bulk of denials are based on not finding someone is disabled. For post-eligibility issues, terminations of benefits are called cessations in the Social Security world. Important little distinction to make because they're called terminations for other benefits. These cessations can happen if you self-report income, or rather if you self-report changes to your income or your medical improvement. You could be found, ineligible, or you can be found ineligible during a continuing disability review where they reach out and ask you, updates on your disability. And you could be found that you've medically improved enough and there's a cessation from that aspect. One of the bigger I guess cessations that we see is being over the SGA limit. So the substantial gainful activity limit is a limit on how much someone on SSDI can make through work every single month. And the limit is $1,620 if you just have a disability. If you are blind, that limit is higher, it's $2,700. So outside of this initial period when you're first on SSDI and you can work a little more, if you're outside that period and you're found to make over that amount every month, it could lead to a cessation. And it's also often coupled with an overpayment as well. There's usually a delay in Social Security stopping benefits, even if you self-report that you're making too much, because people don't know, I've reported that I'm over SGA, but I'm still getting benefits. Do I have to give the benefits back? It sounds kind of like a silly concept, but you do. You can't spend those benefits if you're not entitled to them, or it could lead to an overpayment. And if you are reinstated, or there's no cessation with the overpayment, then 10% of your future benefit check is going to be withheld. If you are no longer eligible for benefits, SSA could start requesting that the IRS reduce your tax refunds, or make claims against your estate eventually for the overpayment. For the appeals of SSDI issues, it's a multi-stage process for both denials, cessations, and overpayments. And it starts with the reconsideration form. And as I note, this can be done at clinic. It's very easy. It's just one sheet. As long as you're, comfortable assessing, the merit of the reconsideration, or even if you just want to point the client and print out the form, help them fill it out, and then refer them to one of the referrals also on the slide. It can be done. It's very simple form. After reconsideration, depending on how that goes, you could be in front of an administrative law judge, then the appeals council in the U.S. District Court. I'll note with disability denials, the reconsideration is also often denied. So you will be, seeing a lot of those types of cases go to the ALJ stage as well. You have 60 days generally to appeal at each stage in this process. For cessations, I note it's important to have a client reach out to their local field office or to one of the referrals, I guess, to determine if they're eligible for expedited reinstatement to get them back on benefits quicker than, the appeals process would be. The overpayment stage is, or the overpayment appeals are the same, reconsideration, etc. But there's also a waiver option. The waiver form, it certainly can be attempted at clinic. Some information can be filled out, but there is a lot of financial information that a lot of our clients aren't going to know or have off the top of their head, unfortunately. So the waiver form can be printed because we have, the clinic resources to print that stuff, but it is very lengthy and can't be completed, I don't think, at clinic. But it's good to point a client in that direction and tell them that there's two parts to a waiver determination, which is not necessarily an appeal, I should say. It's just asking that SSA forget about the overpayment, essentially. You need to prove that you're not at fault for the overpayment. And then you need to prove that or say that you cannot afford to pay it back, or it defeats program purposes to pay it back. And that at fault consideration, there's a lot of ways you can say you're not at fault under Social Security rules. They're all in the POMs. So I'd encourage you to explore that if you're interested. But good examples are, literacy issues, if you never understood the notices to begin with or the requirements of SSDI rules. That could be a good way to say you're not at fault. Also, if you receive misinformation from a federal, employee, that could be a good way to say you're not at fault as well. You can also request a lower amount in repayment as well from SSA. Referrals, if the application is denied based on lack of disability, you can send them back to the local field office, help them with the reconsideration yourself, or to the ADRC to get help with the reconsideration. Filing that after the reconsideration is denied, you'll want to refer them to the private bar or one of these referral options or services. This is because the private bar is entitled to attorney's fees if they succeed in these cases, and there's just a long history of the private bar taking these types of cases as well. For cessations and overpayments, you can refer to Legal Action of Wisconsin. Moving on to SSI. So SSI is different than SSDI. To qualify, you need to file the application, be 65 or older, blind or have a disability defined the same way. You can't possess countable resources, which is how SSA calls assets as resources, totaling more than $2,000, $3,000 for a couple. I'd note there are exemptions to that rule, or what assets are counted rather towards that limit. Like someone's home and their car don't count as an asset for SSI purposes. You can't make more than the federal benefit rate. This is because the SSI benefit, and it's in its name, it's a supplement. It's supplemental security income. So your benefit is calculated by subtracting the federal benefit rate, or your income rather, from the federal benefit rate. And the federal benefit rate is $967 for an individual and $1,450 for a couple. So if you're above those numbers, you're not going to be eligible for the supplement. And then you need to be a citizen or a qualified non-citizen as well. Issues that you face in this stage are similar to SSDI. You'll get those denials based on not finding that the person is disabled. You'll also get denials if they're over the income limit. And certainly the most common denials, I'd say at this stage, besides disability determinations, are being over that $2,000 limit, because it's just such a low amount. And then this is just for future reference, if you want to come back to the slide, the first of all, how SSI is counted, just some of the rules in that top box there, the asset limit at the bottom, and then the federal benefit rate and the state supplement. An important note about SSI, and a good way to figure out if someone's on SSI versus SSDI, is if they're getting an $83 check from the state or deposit from the state of Wisconsin every month, usually means they're on SSI and not SSDI. You can be on both, but it's a sign they're on SSI, certainly, because you'll get that $83 every month regardless if you're SSI eligible or on SSI. Post-eligibility issues for SSI that come up are cessations, just like SSDI. Cessations for financial ineligibility are obviously unique to SSI, though. You can be over income or over resource, and then that'll boot you from the SSI program if you're over the benefit rate, and then you're over the resource limit as well. There's also divestment concerns with SSI. It's not a complete cessation. In most cases, it's really just a penalty period that you have to go through. If you get, a deposit of money and you're worried it's going to affect, your SSI eligibility, push you over the resource limit, so you give it away to someone as a gift or something, that would be considered, a transfer for below the fair market value and thus a divestment. And you'd be subject to some period of time where you can't get your SSI benefit checks. And then they can also find the same way as SSDI that you're no longer disabled, and that could lead to a cessation as well if you don't qualify in some other way, like age. There are also overpayments with SSI. There's overpayments for being over income, and then there's overpayments for being over resource. And there's very important differences, I think, between the two. Because if you are overpaid for being over income, but you're still eligible for some type of SSI benefit, the recovery is going to be, only the difference between what you were entitled to and what you were supposed to be getting, I guess, or what you were getting and what you were supposed to be getting. So it's going to be a lower overpayment than if you're over resource. That's just a very firm rule that you are not entitled to any SSI benefit if you are over resource. So the recovery of that overpayment is going to be a lot more substantial. An important difference. And then really important note is that people who are on SSI are also on SSI Medicaid. So if you are losing your SSI, it's important to tell someone that they also probably will be losing their health insurance as well. The state of Wisconsin is supposed to screen for other programs that they're eligible for. And there is I believe it's a maybe 1 month grace period where you are still covered under SSI Medicaid after you lose SSI. However, you will eventually lose Medicaid, and that search of other programs they're entitled to, we know from experience, just does not happen all the time. So important to tell someone they're losing their health insurance as well if they're facing a cessation. Appeals, same process as SSDI. It starts with the reconsideration, can do it at clinic if you determine that that's appropriate, 60 days. And then the overpayments are the same as well. The waiver I should have mentioned, a waiver for SSDI and SSI can be filed at any time. There's no appeal deadline for that. The difference between an SSI and an SSDI waiver, I believe, is that there's still the two requirements. You're not at fault. You can't afford to pay it back, but there's a presumption that SSI recipients really can't afford to pay back an overpayment. So the stress is more on the no fault argument when it comes to an overpayment waiver for SSI. For referrals, same process. If it's a denial based on disability, new application, those resources, otherwise private bar if it's after the reconsideration stage. Denials based on other factors like being over resource, you can send those to legal action or WISPACT. I'd say only if you're very comfortable that the person is over resource, first of all, and has expressed, some interest in setting up what's called a special needs trust. It's a type of asset or trust that is not counted for SSI purposes, eligibility purposes. It's, the funds are no longer in their control, but they can be distributed for the person's needs. And wants, if they want a computer or something, there's not a lot of limits, but it's specific to the person's needs essentially. So that it's another resource, but Legal Action of Wisconsin, I'd say, is a good start. Cessations and overpayments law. And then I saw on Legal Aid Society's website and on the Gold Guides that they assist with SSI overpayments as well in their health and wealth program. I'm not super confident in that because I just don't know 100%. So if someone could confirm that, that'd be great. But they are a resource on their website and their Gold Guides for overpayments specifically, it said. And then I am not going to go into detail at all about these, but there are a lot of other Social Security benefits to be aware of. Issues are not as common to arise in some of these benefits, especially like retirement. But same appeals processes, same resources with the POMS, legal action, the ADRC for a lot of these resources, same things apply. An example of a Social Security notice, just to show how kind of confusing these can be sometimes. But starting from the top to bottom, you'll see immediately what type of benefit generally someone's on. This says retirement, survivors, and disability insurance. It'll say supplemental security income, if that's the subject of the notice, but this person was on SSDI, so that's why it says that. And then this is a notice of a proposed decision. It'll say notice of decision, or something else if it's a different type of notice, but this is a notice that didn't necessarily come with appeal rights. It was more of like a warning that they're about to make an adverse, usually, decision against the person. And this was a, like I said, SSDI case where they were reviewing this person's work record and found that he was going to be over, there was going to be an overpayment, a cessation. And why I chose this notice is it's a really good reflection of sometimes how long it can take, like I said, for SSA to stop distributing benefits. You see the notice is dated October 24th, 2023, but they are looking all the way back to April 2017 and continuing as when to stop his benefits. So that, could lead to a giant overpayment, and important to just note that. Okay, moving on to Department of Health Services, which covers Medicaid and food share. The where to look for answers, there are federal and state laws that apply to all of these programs. Not Badger Care, there aren't really federal laws per se, but state laws, federal laws for the other. And then the handbooks, which, like I plugged the POMS, I'll do the same for the handbooks. I would just start there. It's what I was told when I was being trained. It contains everything and more. The laws aren't going to necessarily reflect, policy changes that are being made all the time. So just start with the handbooks. They have really great answers in there, and they should have an answer. Otherwise, for the agency you're going to be dealing with under the umbrella of DHS, they're called consortiums. You have Milwaukee Enrollment Services, is the consortium that we're dealing with in Milwaukee County, the subsidiary of DHS in Milwaukee County. I put the phone number there. And then you're also could be dealing with the Center for Medicaid and Medicare Services, might have updates on Medicaid issues as well, as DHS. And then the Access website, that's going to be probably everything in a clinic setting. If a client has their Access account information and is a little more tech savvy, just pulling up their Access account is going to be very helpful. You can look at notices. You can see what benefits people are eligible for, what's going on in their case. You can apply for benefits on Access. So that's a really good resource to remember.
I'm going to jump in really quick and
Yeah.
read the first part of the attendance code, which is the word RAIN, 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 and I'll put it in the chat too. Thanks, Annie.
Yeah, I didn't have any questions, right? Popping up?
Not yet.
Nice. Okay.
You're covering
We're do-
everything so
We're
well.
doing
Now
okay. I'm talking
questions.
really fast. I apologize, everyone. And then you also might get people that mention they have like a private health insurance company popping in. They still might be on Medicaid or Badger Care Plus. If they have that Forward Health card is a good like go-to. Do you have a Forward Health card? They're probably on a Medicaid program. But Medicaid uses HMOs, private insurance companies, to facilitate these benefits sometimes. So they might mention a private insurance company name and still be on Medicaid is an important note. So EBD, Medicaid, elderly, blind, disabled, Medicaid versus Badger Care Plus. There are differences between Badger Care and Medicaid. They're all under the big Medicaid umbrella, but they're completely different programs. And there are, as you can see on the slide, a lot of sub-programs under EBD Medicaid specifically. The big differences are in the financial eligibility tests, The Badger Care Plus uses the MAGI test, it's called, the Modified Adjusted Gross Income Test. It's based on tax rules, so not necessarily like your physical household, but who you file with, and other tax-related rules. I put that there's higher income limits for Badger Care Plus, and that's not necessarily true for all groups. There are higher income limits for like children per se, and they are marginally higher than the categorically needy type Medicaid group that we'll talk about in a second, but they're not much higher. The biggest financial difference is that there's no asset requirement for Badger Care Plus, and there is for EBD Medicaid and Medicaid in general. The coverage groups are also different. One is EBD and the other has a bunch of different groups that are populations we'll get into very briefly. But they have the same notices, the same general procedures, the same benefits. They're both state health insurance programs. And you have the Forward Health Card. Very briefly, the categories of EBD Medicaid, because you could go on forever about, any one of these. Categorically needy, that's people who are receiving that SSI Medicaid or, would be eligible for SSI, Medicaid and SSI. Medically needy, otherwise known as the deductible program. This is kind of a point of confusion for a lot of clients because if they're not eligible for any other programs, they might get a notice that says you are eligible if you pay this amount of money, and they're like, what? I have to pay a deductible to get into Medicaid? That's crazy. And it is a little crazy, but it's mainly based on people's medical bills. That's why it's called medically needy. So if you submit as verifications the amount in medical bills that reaches that deductible number that you need to hit, you can be fully covered by Medicaid. You just need to hit that in your 6-month deductible period. I will say I've had one case in like Ozaukee County maybe where someone just paid their deductible out of pocket right away every month and then got coverage, but that's very rare. And then MAP. MAP is a special program for people with disabilities. It has higher income and asset limits, but you have to work or do in-kind employment. In-kind employment is like you exchange a service or a good for a service or a good at least once a month. And depending on your income, you may have to pay a premium as well. Then there's long-term care Medicaid, institutional Medicaid if you're in a skilled nursing facility or a hospital, and then the waivers program if you're getting services in your home or in a community-based setting. Finally, the Medicare Savings Program. This is a program that helps people cover some of their Medicare costs. There's 3 different types of program depending on your income. And then, what program you're in determines how much of your Medicare costs are going to be covered as well. Eligibility and application concerns for EBD Medicaid and Badger Care Plus. So eligibility for EBD Medicaid, unless you automatically get it through SSI, you're going to need to apply. You need to be elderly, blind, or disabled. Your assets need to be below 2,000, 3,000 for couples. The exceptions, like I pointed out, were MAP and the Medicare Savings Program. You need to meet each program's respective income limits. And just like with SSI, I put that little cheat sheet that Matt created in one of the following slides. And then you need to be a US citizen or qualifying non-citizen. Badger Care Plus, the only really difference is, no asset limit. The income test is slightly different. Well, it's different for sure. And then you need to be a part of one of the qualifying populations. So not EBD, but you need to be, the most common are children younger than 19, childless adults 19 to 64. There's caretakers for children under 18 and pregnant women as well. And there's a couple other categories, but you need to fit that non-financial requirement to falling into that specific population. Issues that arise common at the application stage, especially with Badger Care, is that people are over income, and EBD Medicaid as well, but Badger Care a lot, and then over asset for EBD Medicaid specifically is where people get denied for that. and then failure to submit all required verification docs. You'll often apply for Medicaid or Badger Care, and then you'll get a notice that says, we need more information. And it's like literally what the notice says, we need more information. And people either ignore it, or they don't know what to do with it. It can be too confusing for them, so they forget about it. And then, their case is closed as a result, or their application's denied, rather. And here are the cheat sheets. For the categorically needy limit, you can see that's the federal benefit amount plus the state supplement for categorically needy. Medically needy, it's the federal poverty level, and then calculating that deductible period, how much people need to make in medical bills is the information at the bottom there for future reference. The MAP program, you can see that asset limit is much higher, 15,000, and those income limits are higher as well. You'll be subject to a premium if you are above that 100% FPL and you don't meet any of the other exceptions for having to not pay a premium. And then Badger Care Plus for the childless adults 19 to 64, it's the federal poverty level, no asset limit. And then I put the amount for children under 19 as well. Post eligibility stuff that comes up. Renewals are a big thing in these two programs. Generally, every 12 months, you're going to have to renew your benefits, and they'll request, updated information if they don't have it through the, information data exchange system that they have between agencies, et cetera. They'll ask for bank account information, et cetera. So, following up on those renewals is a really important thing. There's sometimes administrative renewals. If they don't need to request the information, they shouldn't. So sometimes benefits are just administratively renewed, which is great, but not all the time, certainly not in every case. Like I said, there's often issues that arise in this time with submitting verifications. Generally, you should encourage clients to use their Access account to submit information. Long-term care cases might require, faxing or mailing documents just because it's a lot more verifications you need to submit in most cases, but otherwise Access for sure. Even if you're late on a verification, it's important to just get those in because there's like a 3-month grace period where your application will be completely closed and you have to reapply. They'll reopen your application based on the late verifications in that grace period. And then there's terminations for being over income or over asset, for failure to submit for verifications. And then no more overpayments for Medicaid. That was a policy change right about when I started at Legal Action, which is awesome, where they aren't going to, for now, knocking on wood, collect overpayments for Medicaid programs. And then, remember to use Access to view notices to figure out what's going on. Appeals and referrals. In the DHS world, for EBD, Medicaid, and Badger Care, at least, you have 45 days to appeal pretty much any adverse decision, but certainly denials and terminations. The process is called a fair hearing. It's an administrative law judge appeal. This is just like the reconsideration, a very straightforward one sheet form that you can, either print out for someone or help them start at clinic. After that, you can request a rehearing and circuit court review. The Court of Appeals has authority after that, the circuit court stage. An application can also just be reopened within 30 days if it's a denial. So if it's just something as simple as needing, more verifications and the case was closed as that result, it's probably a lot faster to point someone in to the reapplication direction, I'd say, than appealing it. They're going to get benefits a lot faster if they just call and have them reopen their application. Terminations, same fair hearing process, same time limit. A note in the slide, more important to help them fill out or push them in this direction with terminations because it's a loss of benefits. And one of the key things on this fair hearing form is there's an option to, keep your benefits open while you're working with the agency or before a fair hearing decision is made. You have to submit that for that to count for benefits to stay open. You need to submit that before benefits end. So there's that 45-day deadline for an appeal. Benefits are going to likely end before that 45-day deadline. Usually at the end of the month is when the notice will say. So you need to submit that fair hearing before the end of the month and check that box that you want to keep benefits. Is important to remind clients of that. And then again, that grace period, sometimes it's easier just to informally resolve things, send in the, new verifications, work with the agency to reopen the application. Referrals for denials. If the denial requires a new application and the person is on EBD Medicaid or they're elderly and disabled as a Badger Care Plus applicant, you can send them to the ADRC. That's a note with all ADRC referrals. They, have elder benefit specialists and disability benefit specialists, but, you need to satisfy one of those population requirements generally. If they're over income, especially on Badger Care, then you need to send them to the marketplace, the Affordable Care Act marketplace directly, or to Covering Wisconsin is a great resource to help with that marketplace type advice. You can also send them back to the agency or to their access account or to legal action. Terminations, legal action, the marketplace, if it was a termination for over income, like I said, in Badger Care especially, and then the ADRC, if they're Medicare eligible to start exploring better Medicare plans. Another note, just a small thing, that you cannot be on Medicare and Badger Care or the Affordable Care Act program. So over 65, the ACA is not a good referral for people. And then, other benefits issues with these benefits, like a change in someone's MAP premium, just send to legal action. Oh, super brief, because I could go on forever about long-term care Medicaid and estate recovery. Main point, send long-term care Medicaid cases to legal action unless it's someone that's confidently ready to apply. Send them to the Aging and Disability Resource Center because they're the ones who start this application process by scheduling what's called a functional screen. You need to be functionally and financially eligible for long-term care. The ADRC starts that functional screen process. You are allowed to retain more of your income and assets if you have a spouse that's not on long-term care Medicaid, a community spouse, it's spousal impoverishment protections. A client who's on long-term care Medicaid will often say, I get family care, or I'm on IRIS. That's just how clients refer to it often. So that's a good key. They're on state health insurance. It's just that specific program. And then estate recovery, I think the most important takeaway is it's happening more than people think. And anyone interested in or eligible for long-term care Medicaid needs to understand that this is a thing, that the state of Wisconsin is going to want to come back for their money. Essentially, they're going to go after non-probate and probate property that's left behind that doesn't meet one of the exceptions or exemptions in estate recovery once you pass. Like I said, there could be an entire training on estate recovery and long-term care Medicaid alone. So I'm going to move on considering our time. This is what a notice looks like from Medicaid. You can see the consortium is at the top here. It's Kenosha Racine Partners is this consortium, and it'll say Milwaukee Enrollment Services for Milwaukee. Someone's case number is really important information to have if you're telling them to contact the agency. Giving them the case number is really important. You can see that the notices are going to discuss other benefits sometimes as well under the DHS umbrella, like this one mentions food share, even though there's no changes to the food share benefit. And then the next page, it'll say like, what's happening with the benefit, what's changed? Do you have a change in healthcare plans that you're enrolled in? And then it'll say you're now enrolled in healthcare, you're enrolled in MAP and the Medicare Savings Program. And that's great, enrolled in 2 Medicaid programs. But the confusing part of the notices is the next page where it says who's not enrolled, and then it says this person's not enrolled in Medicaid. And a client will read that, anyone will read that and say, so am I enrolled? Am I not enrolled? It's very confusing. Good to think back to the fact that that first slide where I list all of the million programs under the Medicaid umbrella. Medicaid in these notices is really just referring to those medically needy and categorically needy programs. They aren't financially eligible for those two bare minimum programs, which is why he's on MAP with the higher income and asset limits. He's still fully Medicaid eligible and enrolled. This who is not enrolled in Medicaid doesn't really mean anything in this notice. And then on the back of any hearings with an adverse decision, same with food share, you'll get this exact same thing in the food share notices. It'll tell you when your appeal deadline is. And as a reminder, the appeal deadline is not the date that benefits are going to end. It'll say on the first page of the notice when benefits are going to end. Food share, eligibility and application stuff for food share. There are income limits to food share. Your income not only determines your benefit, but it determines if you're eligible. If you're on SSI, you're categorically eligible for food share. And there is an asset limit as well. It's $1,000 higher than Medicaid, $3,000, but there still is the asset limit. There's also non-financial requirements. There's a work requirement, and you have to be a citizen or a qualifying non-citizen. Eligibility is generally based on what they call the food unit. It's whether you're living together and purchasing and preparing food together. Your benefit is based on that as well. And that purchasing and preparing food together thing is really important to remember because a lot of the issues that arise with denials and terminations involve that concept of the agency as this idea that you're purchasing and preparing food together with someone in or out of your household, and oftentimes they're wrong. There are differences if you're EBD. The income limit is a little higher. There's no asset limit if you're below 200% of the federal poverty level. If you are above that, there's a higher asset limit than the 3,000, it's 4,500. And there's also no work requirement over the age of 59. I just outlined the application process there. The most important part of that application process, or difference rather, between Medicaid is that there's this interview. And a lot of people can tend to miss their scheduled interview. They try to reschedule them twice. But if you miss that reschedule, then you really need to try to reschedule it within 30 days or they'll close your food share case. And then denials for non-financial eligibility and financial eligibility can come up. And then another issue that comes up with the application stage is disagreement with the initial allotment, your benefit. Your benefit considers your income, your expenses, and then standard deductions that are just made across the board. If you think that they got your expenses wrong or your income wrong, you're going to have a disagreement with it at the application stage, and that can be fixed. Just for future reference, again, you can go back and look. The maximum benefit amount is on the right, and all of the eligibility limits are there based on household size, and the asset limits as well. Post eligibility issues, just as with Medicaid, there are renewals for food share. Very important note with food share, because there are overpayments in food share. Encouraging clients to update the consortium as income, expenses, circumstances change before the renewal. Within 10 days of the change is what they're supposed to do, but to avoid overpayments, update the agency as soon as these happen before renewal season, before they request that information to avoid an overpayment. Renewals are generally every 12 months. With some EBD households, they're 36 months, though. That's a pretty recent change. The interview sometimes needs to happen also. Another interview needs to happen after the renewal stage. So they might ask during renewals for an interview or for more verifications as well. Like I said, reporting new information can lead to not only a reduction in benefits, a termination of benefits, or an overpayment. And failure to complete a renewal can lead to a termination as well. Yeah, other post-eligibility issues, when benefits are reduced, or even increased, people, tend to get confused, angry, want to appeal things, etc. And I think that the increase in benefits is really important to flag as well. It doesn't seem important, but if it's an increase that isn't warranted, if it's because of agency mistake, it still can lead to an overpayment. As I'll discuss in a second, agency mistake is not an exemption from overpayment, unfortunately. So important to catch increases that aren't warranted as well. Then you have intentional program violations, which are fraud, concealment, or misrepresentation of information. Those often lead to terminations and overpayments and come up quite a lot. Appeals, same fair hearing process, but 90-day deadline for food share, not 45, 90. IPV terminations, the most important thing to note here is that there's an initial hearing that's scheduled and conducted automatically right away with or without the client. They'll get a notice of the hearing. That's important to note, but that hearing's going to happen, and it's important for the client to go and correct the narrative if they need to right away before they have to do an ALJ hearing. This isn't an administrative law judge hearing. It's still within like the food share agency. For late verifications, you can possibly reopen the case, just like with Medicaid, if you just submit the verifications, even if they're late. For reductions, generally, these can be fixed informally with the agency just by correcting the information, submitting the correct information to the agency. Benefits can possibly be backdated as well, so you can get a supplement in your food share benefit for 1 month that covers what you should have gotten in previous months. But you can also do fair hearing. And then overpayments, as I said, there's client mistake, there's non-client mistake, agency error, and then intentional program violations. In intentional program violations, those can and should be appealed, especially when the facts are incorrect. We get a lot of fair hearing cases with intentional program violations that just, actually did not occur. Those can be appealed, but as far as like client mistake and non-client mistake, they really can be a valid overpayment unless it just didn't actually happen. If it was like a miscalculation of benefits, it really could be an overpayment, even if it was the agency's fault for not updating information, still distributing benefits, even though you told them you're making a new amount of money, it still can be a valid overpayment with no merit to appeal, unfortunately. There's also a new process, a compromise request to lower or reduce your overpayment. That can be something that can be printed out at clinic as well, if not just referred to legal action to help them with the compromise request. For denials at the application stage, if elderly or disabled, the ADRC, otherwise Hunger Task Force helps with food share applications. Send them back to the agency or their access account to either get more information or reapply that way, or to legal action. Terminations, legal action, as well as overpayments, but it's also good to go over those merit concerns with overpayments that it just might not be worth an appeal per se. The notices look the exact same as the Medicaid notices. And again, you can see they mention Medicaid as well down there. It just shows, this person's food share allotment as well on the next page. And this one has the same appeal rights as well at the end with the fair hearing deadline. Okay, and in our last 6 minutes, just gonna go over unemployment insurance as succinctly as I possibly can. This is where you look for information regarding unemployment insurance. State laws generally govern, but there's also just like there's the POMs and the handbooks for Medicaid and food share. There is the claimant handbook. And then their version of the access account, where I will continue to plug, you can find a lot of client information, is the DWD website and account. If you have a client that has no idea what's going on in their UI case, just getting their login information and opening it up on your computer to see, the notice that they got. If there's an appeal deadline that they need to comply with, you can file an appeal on the DWD website. Could go a long way. At the eligibility and application stage for UI, the application either online on your DWD account. You can also call and get help applying if the online application is just not possible. You don't have the resources or the literacy, or if you need translation services, they're obligated to provide those as well. Eligibility, really generally, you need to be unemployed through no fault of your own. So, you can't be terminated for misconduct, and it can't be based on your own substantial fault that you were terminated. You also have to be available to work at least 32 hours a week. You have to show that you're doing job searches. And then just to note that this isn't based on need, it's based on past employment and wages, your benefit rate.
There is a quick question asking what is the FS recoupment rate for the various types of overpayments?
Oh, great question. So, Matt, please correct me if I'm wrong, but for the mistakes, it's 10%. And then for IPVs, it would be 20%, I believe. And I think hearing nothing, I think that's correct. But yes, 10% for client mistake, agency mistake, 20% for intentional program violation. But IPVs can often lead to terminations as well, depending on the severity of the IPV. Okay, post eligibility stuff that comes up for UI. You need to do weekly claim certifications that involve verifying you're doing those job searches. If you aren't doing those, you could be terminated if you're not doing your weekly certifications. You could also be terminated for being offered reasonable employment and turning it down without good cause. There are also overpayments for UI. It's not like an appeal, it's called a waiver of the repayment. You can argue for a waiver that there was a departmental mistake by the agency, or by you as the claimant, that it wasn't intentional. But fraud and concealment are going to be pretty across the board valid basis for repayment recovery. Appeals, there's a 14-day deadline to appeal to the ALJ hearing. So once you get that initial determination, if you have a client with an initial determination, appeal, save your appeal rights for sure. Legal action takes referrals after the adverse initial determination. If it has been appealed or there's plans to appeal, you don't take referrals after that point if it's to the Labor and Industry Review Commission stage. As you can see, that's kind of how it goes for DWD stuff. Otherwise, referrals can go to DWD directly, especially if there's tech barriers in application stuff. This is an example of an initial determination and what it looks like. You can see that it says the reason that they're discharged, and then more facts that I blacked out of paranoia to maintain confidentiality. And then this is the notice that's sent to you once you've successfully filed your appeal, and it's you'll get a whole appeal packet with the appeal information, etc. And this just says, you have a hearing, or it's not a hearing notice, but you have appealed this case. And we did it right in the nick of time. There's literally 1 minute for questions. I'm so sorry, everyone, but that's my email address at the bottom. Please send me questions, as things come up. If you're re-reviewing this, if you see me at the UCC, please feel free to grab me and ask me questions. Review this PowerPoint again. But otherwise, thank you guys so much for coming. This is such an important area of the law to me and to everyone else that volunteers at clinic, I know. So I appreciate your time.
Thank you. That was perfect. The second part of the code is cloud, the word cloud, which I also put in the chat. Don't forget to finish your CLE form for attending today. And thank you so much, Annie. If anyone has questions, feel free to unmute or drop them in the chat. Otherwise, I feel like you covered an unbelievable amount of content in 60 minutes.
Yeah, but definitely I can be around for another, 5, 10 minutes if people have questions. But no one else feel obligated to stay after that really insane amount of info.
I do have a question, Annie. It's Angela. Hi.
Yeah.
My question actually is, does legal action do some kind of like, I guess for lack of a better word, like checkup? I'm working with somebody now who I'm thinking like he kind of needs an expert like you who would look at his existing coverage,
Yeah.
medical or income-based coverage that may be benefits-based, and determine what he can do to improve his situation.
Yeah, a hundred
Yeah,
percent. So if
yeah,
it's Milwaukee County,
yeah.
we have a contact that we can email pretty easily just to get like what's going on in this case. For food share, they have a budget sheet and that's how they calculate like the benefit
Okay.
amount. And looking at that budget sheet is often really helpful to determine like, is something going wrong in his calculation? Yeah, we definitely can help out with something like that.
Yeah, and for him, it's more of like an SSDI thing, I think.
Okay, yeah, that would just be contacting Social Security, like a little more complicated because
Yeah,
of the phone call
yeah.
aspect. But as long as he's okay to do like a three-way phone call with someone on our team and Social Security, that's usually a really good way to figure out, what's going on.
Okay. Okay.
Yeah.
All right. So like maybe just through the intake line of legal
Yeah,
action.
yeah, if he mentions an issue with his Social Security disability amount,
Okay,
it should reach us.
got it. Thank you.
Yeah, of course.
Thanks for all this.
Mm-hmm. Any other questions?
Doesn't look like it, so I'm gonna stop the recording and let you go. Thank you.
Yeah, of course. Let me stop sharing my screen.